the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3212, United States of America versus David Paitsel at balance. Ms. McNamara for the appellant, Ms. Kelly for the appellate.
Morning.
Good morning, and may it please the court. My name is Linda Julin McNamara, and it's my privilege today to be here before you representing former Special FBI Agent David Paitsel. This appeal presents some challenging questions regarding the reach of the federal bribery statute. But this court need not grapple with many of those thorny questions that this case presents, such as what's the difference between an official duty and a lawful duty, and do federal ethical regulations of all types always define an official's official duty. We addressed those issues in our brief, and we certainly stand by those arguments. But regardless of how those issues are resolved, Mr. Paitsel would be entitled to relief from his convictions because the district court here committed such a serious and fundamental error in the jury instructions. Therefore, I'd like to at least start by addressing that error. Mr. Paitsel was convicted of bribery under 18 USC section 201 B2C and of conspiracy to do so. That statute says that whoever, being a public official, accepts something of value to do something in violation of his official duty is guilty of bribery and may be sentenced to up to 15 years in prison. Because the bribery statute doesn't tell us what constitutes an official duty, that question is a question for the jury. But in violation of Mr. Paitsel's Fifth and Sixth Amendment rights to have the jury decide each element of the offense beyond a reasonable doubt, the district court here removed that element from the jury's consideration. And here's how that happened. The pertinent bribery count was count 5. Count 4 charged his co-defendant, Mr. Bailey, with a violation of a different subsection, section 201B1C, offering a bribe to a public official, that is Mr. Paitsel, to do an act in violation of his lawful duty, different term. When instructing the jury on count 4, the court told the jury that that offense had 4 elements. First, that Mr. Bailey gave something of value to Mr. Paitsel. Second, that Mr. Paitsel was a public official because he was an FBI agent. Third, that Mr. Bailey did so corruptly with the intent to induce David Paitsel to violate a lawful duty applicable to Mr. Paitsel's position as an FBI agent. And fourth, that Mr. Paitsel had a lawful duty not to use government resources for non-official business and or to keep confidential the information that Bailey sought. It then went on to define lawful duty, saying, for purposes of this instruction, a lawful duty is this, that, and the other thing.
Who proposed that definition with the definition of lawful duty?
The lawful duty definition was proposed initially jointly by the defendants and by Mr. Bailey throughout the course of the proceedings. The jury instructions went back and forth several times.
Sure. Okay, but Mr. Paitsel jointly endorsed that definition?
Of lawful duty.
Of lawful duty.
Yes, yes.
And then on the instructions as to Mr. Paitsel, am I saying the right, Paitsel?
Paitsel.
Paitsel. Mr. Paitsel's instructions, and I take it your objection is with the third one, where the court said he did so corruptly in return for being induced to violate his official duty not to use government resources. That you said your concern there is that didn't leave it to the jury to decide whether there was such an official duty. Who proposed that instruction?
That instruction was initially proposed by the defendants jointly.
Okay.
I don't
know what you mean by initially. This exact language was proposed by Paitsel.
It was. I will say the government has not contended that this is an invited error.
I'm asking you whether it is. They have argued that this, in fact, was proposed by Mr. Paitsel.
These jury instructions were the subject of.
Just asking about this one third.
Understood.
Mhm.
But the definition of the term lawful and official duty went back and forth many
Okay, but
times.
this third one that you say had the district court take from the jury, and I understand that argument, the question of whether an official duty existed and what it was proposed by Mr. Paitsel.
Very early in the
What do you
back and
mean
forth
very
on the
early?
instructions.
I don't understand what you mean by
Well,
early. Did Mr. Paitsel withdraw it?
he did not withdraw it.
Did he amend it?
Excuse me?
Did he amend it?
He did not amend it.
Okay, so early, late doesn't matter. This is his instruction.
Well, I say that because there were various versions of the instructions that went back and forth between the
And the
parties.
district court adopted Mr. Paitsel's.
Ultimately, in the interim, there had been months of back and forth. These instructions
I
were.
understand, but Mr. Paitsel prevailed in that process and had his version of the instruction given.
Ultimately, the instruction that was initially proposed before the parties hashed out what constitutes a lawful
This
duty.
is the one the district court adopted.
That's true, Your Honor.
So,
That's
okay.
true.
Are you aware of, can you cite me any case in which, and there may be some, I just haven't found them. Are there any cases where a court has found plain error for an invited error?
I can't say that I have.
Okay.
I would say I have not found a case that says for an invited error of this magnitude, the court cannot grant relief. Ordinarily, certainly an invited error is something that the court will not entertain.
I'm not sure I followed this whole colloquy. Are you saying that the defendant that you represent proposed the instruction that said it violated his official duty not to use government resources for non-official business?
I can't deny that. The very first version of the instructions that were jointly proposed by the defendants included that language.
Okay.
It did. It did. In my view, that error, especially given the give and take between the parties and the court over that.
Can you point us to anywhere in the record where Mr. Paitsel or another one of the defendants were said, and it could be inferred that Mr. Paitsel joined in the objection, where there was an objection to that particular language that was given?
What I can point you to is docket entry 196, which was one of Brian Bailey's, the co-defendants, proposed additional jury instructions. That instruction.
Where's that in the joint appendix?
I'm sorry?
Where is that in the joint appendix?
I'm sorry, I don't know that it is in the joint appendix, but it's at docket 196. This is Mr. Bailey's notice of additional proposed jury instructions, and I see that I'm nearing the end
You
of my
can
time.
keep going, that's fine. We'll have rebuttal time.
That this proposal said, lacking any statute, regulation, or written policy. I'm sorry, I'm reading, let me see. Oh, here we go. Courts have not yet grappled with serious factual disputes over whether there exists an official duty or not, as the parties will do in this case. The Bailey cited Fernandez, which is the case we cite in our brief, the unpublished case out of the 11th Circuit, which is the only one that I've located that actually attempts to define that term, and then proposed a definition of official duty or lawful duty, as lawful duty or official duty means a public official's job responsibilities as dictated by governing statutes, rules, and regulations.
Did your client join that submission?
I would not say that in any type of formal way he joined that submission. I would say he did not object to that submission. And these definitions were discussed repeatedly throughout the months preceding the
And
trial.
If I'm understanding that docket entry correctly, it suggested that lawful duty and official duty were synonymous.
It certainly conflated those terms.
I
You
want to
argue
ask you.
now it's not the case. case.
Sorry.
I'm sorry.
What you argue now is not the case.
I think that can't be the case.
I'm sorry, Judge Randolph.
Yeah. I want to change the subject for a moment because I'm not entirely sure I understand what this clear thing is. And I'm not entirely sure that I assume that the only thing that Bailey wanted was the telephone of the individual. Is that correct?
He wanted contact information, whether it was a telephone number, an address.
Well, the addresses, it would seem to me he had the address because he was talking about a apartment building.
Sure,
So that's the address.
sure.
So the only thing left was that he had any use for was what he was trying to get is the telephone number. And it's only because of technology that he needed that. Correct? It's cell phones. It could have, so one of the analogies that occurs to me anyway, is that this is like somebody calling up an FBI agent who has, we used to have the white pages and the yellow pages, who has a particular telephone directory and asking, please look up this following number. I mean, that's all it was. But the clear, whatever website is run by Thomson Reuters,
It is.
a corporate. Where does Thomson Reuters get the information?
Thomson Reuters pulls the information from all types of publicly available.
It's all publicly available.
They describe it as public, and I'm over my time now, if I could continue. Public and proprietary sources. It is a private company that pulls information from various sources on the internet.
You may not know this, but in fact, by we, I mean the judges on our court and our law clerks have such a directory too, except it's not Thomson Reuters, it's West. And there's websites where you can go on, you put the name of a person in there and get all kinds of information about them. It's the same thing, I think. And one other point, at some point in my reading of this, it indicated to me that the statement that official duty not to use government resources for non-official business is itself incorrect. Wholly apart from whether that's a directed verdict by the trial judge, it's not a correct statement of the law. And the reason is because there are all kinds of exceptions to using government resources. If somebody places a telephone call to their child or to a friend or something on a government phone, that's using government resources, but it's not a violation of official duty. Is that correct?
Judge Randolph, your points are all well taken. What happened here was the use of a tool, a government resource, to find information wholly unrelated to the work of the FBI in general, much less to the work of this particular agent. It's really no different.
How can you say it's unrelated to the work of the FBI? The FBI has to track down people, witnesses,
Sure.
et cetera. That's the whole reason that they have access to it.
Sure they do.
As a public defender, we had access to similar types of databases, and that's what we used it for, to track down witnesses.
By that logic, anything in the FBI office is used in pursuit of the FBI's mission. The color copier in the copy room, if used to make a person's flyers for their child's school play in exchange for tickets to the play.
But the point of the clear notice and the point of the way that this works is that when Agent Paitsel accessed that database, it asked him whether he had a permissible use. And he clicked law enforcement as the permissible use. And that is how he accessed this data, because if he had not clicked law enforcement, he would have not had a permissible use and he would not have had access to the database. Isn't that the evidence that was presented at trial?
Yes, that's the terms of the contract between this tool and the FBI. But, and listen, I don't dispute that maybe he probably shouldn't have done that he shouldn't have used this resource in this way. But was he on notice that he was going to be convicted of a crime punishable by up to 15 years in prison for looking up contact information in matters wholly unrelated to matters before the FBI? And in my view, that is an incredibly expansive view of the bribery statute, one that does not give thousands of government employees notice of what's prohibited.
It strikes me as odd that if you take our in-bank decision in Valdez, that it's pretty clear that there's no real distinction between what this guy did, your defendant did, and what the individual in Valdez did. The only difference is he was getting license plate numbers and your client was getting telephone numbers. But the other difference is that we reversed that fellow's conviction for accepting a gratuity, which is a lesser offense. But what's going on here is a conviction for the greater offense. And that seems to me totally out of kilter.
I think that's a really important point, because the gratuity statute, although it hinges on the definition of official act, is punishable by only up to 2 years in prison. Valdez's conviction was reversed. This defendant was subject to a statute that was punishable by up to 15 years in prison. And I don't think you will find any cases in which a person was convicted of bribery for doing something wholly unrelated to the decisions, the work, the internal workings of the office. This was the use of a government resource, for sure. But was it
In Valdez,
bribery?
we said, and this was on bank, page 1327. Our decision therefore plainly continues to allow bribery prosecutions when, for example, someone offers something of value to induce an official to provide information in violation of official duty. Isn't that this case?
I think it is.
It is this case.
No.
Okay,
Information, the term information could be a lot of things. How do I get to the office? That's not the information that we're
He
talking about
didn't
here.
provide that. He provided information from an FBI-specific database that required him to type in an FBI purpose when he accessed it. And it was part of his job to deal with technology.
Judge Millett, I don't think it's fair to call it an FBI-specific database. It's not a database at all.
Is it a contract the FBI had with a provider?
It's a contract the FBI had with the
I
provider.
could rent, if I were willing to pay for it, I could have that.
Correct.
The difference, the taxpayers paid for it. And so this guy got the
Sure,
benefit of something the
but-
taxpayers paid for. He didn't pay for it himself. Had he paid for it himself, like Judge Randolph suggests, we would have no case. But in fact, he let the taxpayers pay for it and pay for this man's salary and pay for this computer. And then he spent his time typing in a specific code that says, I'm doing this for whatever purpose he did, lawful purpose.
The taxpayer,
Lied as to why he was doing it. This is an on-bank decision. I feel like if it says in terms, I get that Judge Randolph and Judge Henderson had a different view in that case, but I think I'm bound by the on-bank decision. It says in
ultimately,
terms, and it says, even if the information is publicly available, it still counts.
well, it doesn't count for an official act, which is what Valdez was. But ultimately, the misuse of any government
But this
resource,
case is about official duty. right?
it is about official duty.
In the language that Judge Millett explained to us why that language in Valdez that says, our decision therefore plainly continues to allow bribery prosecutions when, for example, someone offers something of value to induce an official to provide information in violation of official duty. Are you saying that that's not really the law of how a bribery prosecution works, or is it your argument that this was not an official duty?
Exactly that. That statement turns on what's an official duty, provides information in violation of an official duty. So you can't just stop at the provides information. It has to be in
What did
violation.
you argue below is the meaning of official duty?
This was not discussed.
You
This
didn't
did-
object below?
Did not.
So we're hearing for the first time here on a.
Well, I take that back. I'm sorry. In terms of the motion for judgment of acquittal, he did argue that under Valdez, this was not, the evidence showed that he did not violate an official duty. Now, there were no proposed
That's an
definitions.
evidentiary argument. I'm asking, I thought you were making a legal argument to us now as to what official duty means. That's not an evidentiary argument that was raised below. So I think this is difficult, right? Valdez is difficult. We're on common ground there. But I don't know how we can decide that this wasn't part of his official duty without a legal definition that you're proposing of what counts as official duty. What is that? Where is it in your brief?
Well, I proposed a definition, and that is a duty emanating from his job responsibilities. But I will say,
Duty, one of his duties emanating from his job. So it's not just his job responsibilities, it's obligations that emanate from his job
Particular to-
responsibilities.
right,
And so does that include not using government resources for personal gain?
I would not call that an official duty. I would call that an ethical responsibility.
What's the difference?
I think there has to be a difference. Otherwise, as Judge Randolph points out, every single violation of, I came to work late, or I didn't, I had a duty to.
If we were writing, we have to write an opinion with a rule.
Mhm.
And help in future cases, judges write jury instructions. So what would be the rule for the dividing line between when something is an official duty and merely what you call an ethical duty? What's the rule?
I think it has to be something emanating from the office that he holds and relating to his job responsibilities. And I will say
That's
that.
the purpose of the bribery statute is designed to punish people who are performing their duties in a way that is adverse to the government, to the public and everything else, because they're getting money to do it. Right? And it's hard to see how what happened here is an inducement to do something that they would not otherwise have. I mean, it doesn't fit. I mean, that's the basic problem.
Exactly. The bribery statute is about corruption of government functioning, duties, purpose. This is not that. And that's the problem here. And I will say
I understand, this is hard. We can't write opinion that says this is not that. And we have to have a definition of official duty that is distinct from official act, right? Being induced to do an official act,
yes.
right? So this seems to be departure from a duty.
But is it an official duty is the question.
That's what I meant, right? I'm still struggling. And if you can point me where it is in your brief, that you tell me what the legal test is you want us to adopt, that would be helpful. But I don't understand how your proposed distinction writes, and we're facing an en banc decision here that tells us this exact prosecution can still go forward. And you're turning it on official duty. I get that. What is your definition of official duty that is distinct from being induced to do an official act, to do something in his job?
Well, I think that the closest thing we have, and as we suggested, as the 11th Circuit defined it in Fernandez, its ordinary meaning encompasses a public official's job responsibilities as dictated by governing statutes, rules, and regulations. Now, I don't know that tells us a whole lot. And I will say, Judge Millett, you said.
Did he violate a job responsibility?
He did not.
Is it, okay.
It was not.
All you're doing is substituting one word for another. responsibilities for duty. And I get that. It seems to me I've seen cases doing job responsibilities, but I've also seen ones that say you have a duty not to commit crimes while doing your job.
Mhm.
Okay,
Mhm.
I don't know, that's a job responsibility on any paper somewhere, but that also has been defined by courts to be part of a violation of official duty.
Mhm.
And so if what he did was a criminal action, theft of government property for personal purposes, then that would be a violation of his official duty, right? It wasn't that he just did this for a friend. He took money to do this for a friend. And so he used government resources to pad his own wallet.
But by that
And
logic,
so why is that not, why doesn't he have a duty to only use government resources for government purposes?
by that logic, using the government car, which you can only use to drive to your government responsibilities, if you use the government car,
I don't know that that's true. I haven't seen what the rules are governing. They may have a de minimis exception as
No.
well.
I can tell you,
Could you finish your answer?
thank you. I was a former prosecutor and I knew in our office, we could only use the G car to go, for example, to oral argument.
Mhm.
And on the one time when I said I stopped by to get my haircut on the way to oral argument, I was admonished, you can't do that. You can only, and I was like, oh, I didn't know that. I didn't realize that. Now, if I had instead dropped off a friend at the airport and on the way to the airport, my friend bought me lunch for doing that favor, under that logic, the use of the government resource alone should have put me on notice that I could be convicted of bribery for that. And I don't see that this statute puts government employees on that notice of
More
that
like a
type.
gratuity, but anyhow, and you'd probably be okay. But my point is that define government, how do I define what his responsibilities are for me? If that's your test, job responsibilities.
His job responsibilities
In a
are,
way that doesn't turn official duty into not doing an official act.
it has to be related to the work of the office that he holds. And that is related to the work of the FBI.
Mhm. But he was also particularly the tech liaison. So he had particular obligations with respect to technology usage.
This has nothing to do with that.
I'm asking, that was his job.
It was,
Okay.
it was.
And
but-
so, was it part of his job to inform other FBI employees about the proper usage of FBI
Was
technology
not.
equipment?
It was not, certainly not with respect to the use of Clear. It was not. His responsibilities, and honestly, there's not much in the record about what his
Well, then
responsibilities
how can
were.
we adopt that as a test and say it wasn't met here?
As my husband always tells me, when he says, where is something? And I say, I don't know where it is. And he says, well, then you need to look everywhere. And I said, well, I don't need to look here. He says, well, if you don't know where it is, you don't know where it's not. This is like that. We might not know exactly what is an official duty, but we know it's not this.
I'm trying to understand your theory. Is your theory that it's bribery if he does something that falls within his job description in exchange for a payment? But if he does something, even using official resources, but that it's really outside of what his job description is, then that falls outside of bribery? I'm trying to understand the line that you're trying to.
I think that's probably too narrow. Because I think because he's an FBI agent, he reveals secrets about how the FBI works or some type of private information of the FBI that has nothing to do with his particular role, I think the bribery statute would cover that. And I think there's plenty of cases in which things like that have
I'm very
happened.
confused now. You just described to me something that is not in his job responsibilities. You said it was outside of his particular role, and if he did it, it would be bribery.
I think it would have to be. It's related to his role at the FBI. Otherwise, if the receptionist at the FBI office reveals information
I
about
want to
that,
go back
can't
to the
be.
example you just gave me. I had thought your argument was it's only bribery if he does something he shouldn't do within the scope of his duties. But then the example you just gave was he goes way outside his own duties and does something wrong. That would be bribery.
But the duties emanate,
Did I misunderstand you?
well, I'm not sure I can answer
Why
that.
don't you give me an example, try an example again of what would be bribery? Because it would be a deviation from his job responsibilities, if that's your test.
Okay, he's not a field agent. He doesn't do things with respect to investigations. But he goes into a friend's office and he looks at paperwork or finds the name of an informant or something and sells that information. That's related to the work of the FBI. That's a private secret matter. If he sells that
That's
information,
bribery.
that's bribery.
Okay, but so then your definition
It has to be.
of official duty is something that's not part of his job responsibilities. If he goes outside his job responsibilities.
And the
Wait,
responsibilities, I'm sorry.
I gotta pin this down. I have completely misunderstood what you said before. So your vision of official duty is things that are outside your job responsibilities that you do for money.
I mean, I think they could be. I just think it has to be. This is about corruption
Okay,
of
okay, okay.
government.
So then is your theory then, if he does something within his job responsibilities, it's not bribery?
Oh, no, of course, it's
Well, then
bribery.
if things
Of course,
in
it's
his
bribery.
job responsibilities and outside his job responsibilities are both,
Judge Millett, it has to depend on what those things are.
well, then that's not a legal test.
I-
I'm sorry, I can't, I understand that it's your job to argue that this doesn't count, whatever the test is, but we can't write an opinion that says, whatever the test is, this doesn't count. We have to have some sense of what the statutory term means, and it has to be so clear that it justifies departing from this on-bank language. So if you've said if he does something he shouldn't do as part of his job responsibilities, that's bribery. And if he does something that's not part of his job responsibilities, that's bribery. Not sure I know what's left.
My proposal is that the duties have to emanate from the position he holds and from the place that he
Did his
works.
access to this clear database, did he have access to that because he worked at the FBI?
He did.
Okay. And that was the only reason he had access to this information?
That's true.
Okay. And was this database one that was only to be used by FBI agents as part of their work? Because they had to type in a code for what they were doing.
Well, it's not a database, it's a tool.
Whatever.
tool.
It's a
So
tool. It's a program that leads to information.
it's an information amalgamator that allowed you to search like
Whatever you wanna call
Westlaw,
it.
like Westlaw.
I'm back to my point. He only had access because of his position in the FBI.
He
You agree
did.
with that?
Yes,
The FBI requires any agent using it to identify an FBI purpose for doing so, correct?
correct.
Okay. Why is that not a duty?
It's
Why
a,
is that not something that he can only do because of his position as an FBI agent and can only be used as part of FBI work?
it's a specific kind of duty. And I think the misuse of a resource like this resource, just like any other resource, is an ethical violation. It is.
So,
Any other?
so let's suppose his friend asked him, I'd really like to know whether there's any wiretaps on my phone or whether I'm being investigated. And so what Agent Paitsel is alleged to have done is to have accessed FBI databases
Mhm.
that, list all wiretaps, all investigations, et cetera. And he does that search and he reveals to his friend that there is indeed a tap on his phone. And his friend tells him, he'll give him $5,000 for, doing the search and telling him. Is that bribery?
I think everyone in this room would agree that it is.
So what is the difference between that hypothetical in what happened here as far as the dividing line between what's bribery and what's not?
Because what that would be the corruption of the function of the FBI. What happened here was not. It had nothing to do with the function of the FBI.
So if his friend in this case said, you know, there's this apartment building and I want to try to buy the TOPA rights from all the tenants, but I don't know who all of them are or how to contact them. I'll give you $5,000 to do that. And what he does is he goes door to door and flashes his FBI credentials and says he's conducting some sort of investigation. And he gets the name and phone number and apartment number of everybody in the building and then gives that to his friend. Is that bribery?
Could a jury find that to be bribery? I think a jury could probably find that
meets the
any
definition of official duty.
official, any FBI agent who misuses his badge for private purposes, I think could be found that could fit the
So
definition.
misusing your badge for private purposes would be in violation of his official duty?
I think it would be reasonable for a jury to find that.
I'm sorry, but I want you to answer Judge Wilkins' question, but that seems to be dodging the question. That would include, that is part of your official duties, is how you use your badge.
I mean, we need your, I guess the better answer for what I'm trying to get at is, are you saying that we would rule as a matter of law that can't be an official duty? Because what you're trying to do is say legally what
Yes.
can and can't be an official duty. So are you saying that yes, legally that could be an official duty if the jury so concluded, or are you saying that
What happened
no?
here?
No. My hypothetical of him going door to door and collecting information on each tenant. Or are you saying that if those were the facts and he were found guilty, we would have to set aside that conviction because that couldn't be a violation of official duty?
I think I would probably not be here arguing a sufficiency of the evidence deficit in that situation.
So what is the difference kind of legally? Help us understand the difference legally between him doing that and him accessing this database.
Again, I think it comes back to corruption and what corruption is and what the purpose of the bribery statute
You had to
is.
put your badge number in to access the clear database.
I don't know the answer to that, but I don't think so.
So misuse of badge is not an official duty. You don't define it based on that.
I think what any particular official's official duties are is very dependent on where they work and what they do. And that's why this is really difficult to put a definition on. And I get that. And that's why I come here saying whatever that definition is, he did not violate an official duty here.
Well, you can't say that because if the definition is the one from our on-bank decision in Valdez, he did. And that's why I think we're pushing you. It's really hard for someone to come here and go, I don't know what the test is, but just please say my client didn't violate it.
Well, Judge Millett,
Expecting attorneys to give us what the legal test should be. And
respectfully, Valdez does not define what is an official duty. It does not.
well, but they definitely said something that's a violation of official duties. They did say that, and that is getting something of value for disclosing information.
In violation of an official duty. It leaves that question
It would
completely
allow
open.
bribery prosecution for violating your official duty.
It does.
When you accept something for value.
To
Disclose
violate
information.
your official
No,
duty.
that's what they're saying it would be a bribery prosecution for violating official duty if you do this.
It
So
has to,
they're-
but the
I
quid
think they're
pro
telling
quo,
us that that's
the quid pro quo has to be to violate the official duty. That can't be written out.
And they're saying this is an example of that.
I don't read it that way. I read it as providing information in violation of your official duty is bribery. And I think that that's,
Explain to me in simple English why providing this information from an FBI-specific database that required an FBI-specific justification that only FBI agents could access. And this guy Bailey could not. Why that information, just explain to me why that was not, disclosure of that did not violate an official duty.
I go back to the purpose of the bribery statute.
No, I know what the purpose is. It's coercion. We're just going in circles here. Coercion, bribery is a form of coercion. So just saying it's not bribery does not tell me your understanding of why this information is not the type of information. You've agreed that other types of information. If Bailey had said, can you please get for me contact information, phone number, apartment number for X person, because they owe me money and they're avoiding me. I'm going to get my money. I want to get my money. And there's a bribe.
Mhm.
Would that be a violation of official duty?
I don't think so. I think if
Aiding and
this,
abetting a crime? No. Who said I'm going to beat the person up? Get it for me, so I'm going to find him and beat him up. That would be? Use the same database to get the same information because I want to find this person, have him either give me the money or I'm going to beat him up. Would that be a violation of official duty?
I think that a law enforcement officer probably has an official duty not to aid and abet a crime. So I think I could agree with you that that could be a violation of an official duty.
Okay, so the only difference here is that it was being used to give this person an unfair advantage in the TOPA scheme
Mhm.
for hunting down people to get their rights from them.
Not a crime.
That's what makes it not an official duty.
Not a crime. It's not a crime.
I understand. Well, that begs the question, but
You're saying that because the ultimate use of the information wouldn't facilitate a crime, that should be kind of mitigate against it being in a violation of official duty. Is that what you're saying?
Well, that and the purpose that was for the request.
Or the detection of a crime. It's not just, it can't be just the
Mhm.
preventing the detection of a crime would seem also to
Mhm.
be covered by your definition.
Mhm. Yes, and I'm sorry, Judge Millett, that I don't seem to be answering your questions. As I said, this is a really challenging area because the statute, and I guess I need to point out here that the statute also has this whole lawful duty term that has to mean something different than official
when
duty.
you propose a definition for that, which the district court adopted,
Correct.
I don't think you've.
But when you talk, and I'm not disputing that, I'm just saying that there has to be a difference between lawful duty and official duty. And a lot of what we've been talking about here today and a lot of the back and forth have been duties that emanate from laws, from ethical regulations and other things, but not necessarily from the particular job responsibilities and role of this person.
Lawful duty instead of official duty, would there have been a violation here?
I think there could have been. I do.
Why would Congress write a statute that makes it a crime for someone to bribe an official to violate this rule against misuse of public property? Because that would be a lawful duty.
Mhm.
But not make that same action a crime for the official to accept that money and do the requested conduct.
I can't answer that question. I mean, all I can say is Congress
Well, you
used,
insist
Congress,
lawful has to be different than official, but then that suggests
Well, that's
really a lack of parallelism in the
well, that's,
statute.
I mean, that's just a well-established principle of statutory construction, that if a term is used in one part of the statute and a different term is used in another part of the statute, they cannot mean the same thing.
Help me understand this. So the jury found convicted on count 4,
Mhm.
I think was the lawful duty
Right,
count, right?
right.
and they were instructed a lawful duty is any statutory, regulatory, or official duty imposed upon and made known either orally or in writing by virtue of and specific to her position.
Mhm.
If instead of giving that instruction just for count 4, the judge had given the same instruction count 5, but it just said an official duty is any statutory, regulatory, or official duty imposed upon and made known either orally or in writing by virtue of and specific to her position. Would that instruction have been error?
I think it probably would have with respect to official duty.
And why?
Too broad.
What's
It's too
specific?
broad. It's too broad.
Too broad, why? What is the part of it that is too broad?
Anything made known in terms of, it covers too much. It doesn't,
Anything imposed upon and made known either orally or in writing. So what's the problem with made known? I mean, you need to have notice, right? That whatever it is your official duty.
yeah.
So what's the problem? with
Yeah,
that?
I'm looking at that definition now. And so your question is, if it had said an official duty is any statutory, regulatory, or I don't know what the last word would have been imposed upon. I mean, I believe that definition is probably, again, too vague because I think it includes ethical violations that no reasonable government employee would be on notice could result in a bribery conviction.
It's not just that the regulation or the information that you're told is what causes a bribery. It's that you took money from somebody not to do it. Why isn't that bribery? It may not be, worth a ton of money, but the violation of duty here was I took money to do something I knew I wasn't supposed to do.
But
And I could only do it because of my position, by virtue of my position. Why isn't, I don't know, you keep acting like it's fine, taking pencils home from work.
don't think it's fine.
No.
I don't think it's fine.
But it's, the bribery here is, unlike gratuities that come sort of as rewards after the fact, this is upfront quid pro quo. I will pay you money to do this thing that you can only do because of your official position. And you're not supposed to do it. I don't understand what the great concern is that is some travesty of law to make that unlawful.
Because there's,
Don't take money to do things in your official position that you're not supposed to do and you're not supposed to do. There's no question of knowledge or intent here.
ultimately, I don't think that the bribery statute is intended to criminalize the violation, the misuse of every single government resource that
Not the
has,
misuse. It is taking money
right, in
to
exchange.
misuse it because of and using your position to do something. And you're selling your position. You're selling your access. You're selling your capacity to do something that others can't do. Right? You're selling out the taxpayers.
The statute is not just about money. It's anything of value.
That's fine. All right, it's a diamond ring, whatever it is. You keep saying they don't want to make it bribery because all they did was violate a little ethical duty. It's not that. It's that they took money. They had an upfront agreement, a quid pro quo agreement to do something that he could only do because of his position.
There was a quid pro quo agreement for him to use a resource that he had as an FBI, as an FBI agent.
To use a resource the FBI had.
To use it, but unrelated
And
to anything, any secrets of the FBI, any work of the FBI. And
So if what happened here instead was simply that this FBI agent gave one telephone number to Mr. Bailey, and then Mr. Bailey in response bought him lunch as a 15-year felony under that theory. That's crazy.
That doesn't
Completely
sound
my
like a
point.
quid pro quo agreement to me. Maybe
if he
it's
said,
wording.
if Mr. Bailey had said to him, "Hey, Dave, I'll take you out to lunch if you can get me this guy's number," Is that bribery? I just don't think that's what this statutory,
So you agree or concede that he violated the statute, the Graham-Leach-Lively Act,
I don't know.
to access this information if he accessed it without a permissible use?
I'm not sure that he accessed any information in violation of that act.
Well, I mean, that's the whole point. Compliance with that act is why you have to click
Mhm.
that you have a permissible use.
Mhm.
Because if you don't have a permissible use, then you're in violation of that statute.
Well, you're in violation of the terms of the FBI's contract with Clear.
The Supreme Court in Sun Diamond, seems to me, answers a good many questions that have been asked today. And one of the questions, or one series of questions, was addressed by Judge Williams in the in-bank opinion for our court, when he interpreted Sun Diamond to mean that the court rejected the theory that the official acts definition covers any action taken in an official capacity. So the fact that Mr. Paitsel was an FBI agent acting in his official capacity is not enough.
He was not, that's just not what happened here.
That was the gratuity statute, right?
It was,
Yeah.
it was. But again, when I get back to these gratuity statutes cases, those are all 2-year penalties. And
Yes, because you don't have a quid pro quo.
you don't have a quid pro quo, but all of those cases are about duties tied to the work of the agent, the person, the HUD official, the inspector, corruption in the function of government. And that's not this.
Just to clarify one more thing, we've had a helpful discussion here. But I think you agreed that you did not raise this argument in district court.
The sufficiency argument?
No, that what the meaning of official duty is.
That's true.
Thank you. All right.
Thank you very much. I
We have a long
appreciate the time.
We'll
Thank
give
you
you
so
some time
much.
for rebuttals.
Thank you very much.
Thank you, Your Honors. May it please the court, Catherine Kelly on behalf of the United States. Your Honor, in this case, it's clear that this is very similar to the Valdez case, in which this court indicated very strongly that same type of actions taken by an MPD agent giving a friend information from a database from MPD in return for money is essentially the same thing that happened here. There was, again, a database the FBI had. Mr. Bailey offered him money to look up tenant information, and Mr. Paitsel then used that database to do so. This
Is that a
court,
violation of law or just a contract?
it's a violation of his duties as an FBI
Also a
agent.
violation.
So
Judge Wilkins mentioned the Graham-Wiley statute. Is there a statutory prohibition?
There's a statutory prohibition to using information in the CLEAR database for other than authorized purposes. So going into the database, you have to check that you're using it under that Graham-Wiley statute or 2 other statutes, and then give permissible purposes for
That's a
each.
Statutory?
Mhm.
There-
What's the statute?
It's about the use of personal information.
There's another one, I think it's it's like a motor vehicle driver's
Correct.
Privacy Act, because it has information in there from DMV database.
That's correct. And I believe there was another section about voter registration information as
Yes.
well.
There's
So-
a registration statute.
We said at trial that those were showing that he was acting corruptly by going into the database and checking off that it was under one of those conditions, and then citing a permissible purpose before logging in. We based his official duties more on Mr. Adaroba's testimony, his supervisor, and the regulations about the conduct of an FBI agent.
What were the duties that you had to check off?
in order to get into the,
Well, not in order to, I mean, but you had to
Permissible use.
answer the question. What was the checkoff? And who devised that? Was that Thomson Reuters?
I don't know who devised it.
It may not have been the FBI. It may have been the private company.
It wasn't clearly laid out at trial who actually made the
But anyway,
login
what-
screen.
what-
Compliance with statutory obligations. So
What
I would
were
have
they?
thought FBI would have
The
put it.
three things.
I'm sorry, Your Honor.
What were the three things that you had to check off?
You had to check in, if I'm recalling correctly, that you were searching under the Graham-Leachy-Bliley statute, or if you were going to get voter information, you would have to check off that you were going into that section or the DMV section. Anytime you checked off those, then there would be another list of permissible purposes. For instance, the one.
Investigation was one. I remember that right.
There was one, and I'm sorry, I'm not remembering the exact wording of each permissible purpose, but essentially you were doing it for federal, state, or local law enforcement reason, if I'm
What
recalling
is the
correctly.
difference between that database and Wales?
My understanding from what was stated at trial is that it's an aggregator of a lot of information that you can get from other sources.
Wales contains a lot of non-public information,
Correct, about somebody's
but
criminal
clear
history and so forth.
it's just an aggregation of public information.
It was an aggregator of public information, and the version that was set up specifically for the FBI, which is maybe how the specifics about the various motor vehicle statutes and voter statutes came about, was done specifically for the FBI. I don't know who came up with the
I would
language.
assume if you're getting voting records or DMV information, you're getting access to non-public information, social security numbers. driver's
I know there was social security numbers available because part of the information at issue was,
Right, so it's not all
Social
public
security.
information.
it's not everything in it is
Government
public.
information, but it's not public information for sure.
And I recall also in the FBI version, there was
That doesn't
information
follow. I
about
mean,
people's,
This is a
Criminal.
private company. How do they get social security numbers? It has to be public.
They can get them from
To
credit
get them-
agencies.
exactly, Your Honor.
They can pay for proprietary information.
Correct. And there was discussion about Experian and
access.
TransUnion and so
It's
forth
not
being,
accessible to an ordinary member of the public unless they're paying for this database, I guess.
right.
And I assume when people have access to this database, are there laws that govern confident, maybe that's what this process is of checking the boxes, that they're not taking social security numbers and doing identity theft.
Right. I mean, ultimately what you're doing and you're logging into Clear, you're checking these permissible purposes. The permissible purpose
How can
are
you say-
related to an
how can you-
FBI
How can
duty.
you say that's right when the Clear is available, versions of Clear are available to private parties who are members of the public if they pay the fee, right?
And then there was also the FBI had its own version.
I know, but you don't know whether the version of Clear that is available to somebody who wants to pay for it also contains social security numbers.
I don't know.
You don't know. So when you say that, yes, the FBI had it's exclusive to the FBI to have a database with social security numbers on it, you don't know that.
No, I know. And I did not mean to say that the FBI had
Well,
exclusive.
That's what you said, is I
I'm sorry, Your Honor, that I misspoke. But my point was that the
Yeah, it's just
FBI,
that the FBI had its own version, it had a different version of this database than, I could go buy in my private capacity.
I don't think you could buy the FBI version in your private capacity. But what was really made clear at trial through Mr. Adaroba's testimony,
I just want to be clear on that. So there's an FBI specific version of this database.
that's my understanding from the
Private
testimony.
Company X couldn't buy. They could buy a different version.
It
of
could
the
buy a different
database.
version.
And do we know what was special about the FBI version?
I recall the witness from Thomson Reuters indicating that there was specialized information about criminal history and whether or not someone was incarcerated and so forth. But ultimately,
That's not private information. Whether, you can go on the Bureau of Prisons website, I've done it. To
you
find
can
out.
do that, right?
Yeah, and you can find out whether somebody's incarcerated or not.
But the whole point, though, was that what was made very clear at trial is that, as Mr. Aroba testified and as Agent Waltz testified, you could not use the FBI version that you were allowed access to as a special agent for anything other than FBI purposes. And it's very clear what Mr. Paitsel did here was not for FBI
What
purposes.
is, you mentioned the DMV and the voter information. What does the Graham-Wiley-Leach, what kind of information does that one cover?
I'm recalling correctly, I believe it's just private, like personally identifying information, but I'm not absolutely certain as I stand here.
But the testimony at trial was that there were different permissible uses and you had to pick at least one. You
Correct.
could pick more than one. And that to access this information, he clicked law enforcement.
Correct, yeah, he's used
If
several.
he hadn't have clicked that and hadn't clicked any other permissible use, then he would not have been able to access the data, right?
That's correct.
The search function wouldn't have worked. He
Correct.
wouldn't have been able to go further. It's
Right.
kind of like having to agree to terms and conditions or something before you can go further on a website.
Exactly, Your Honor, yes. So he couldn't have gotten to the information at all.
So he had to make a representation that he had a law enforcement use in order to access the data.
That's correct. Yes.
Go back 50 years and two friends call each other. One of them calls the other, who's an FBI agent, says, "Hey, Joe, I've lost my telephone directory. Will you look a number up for me?" Is that a violation of his official duty if he did that?
No, it's not.
No.
No.
What's the difference?
The difference is this is
And forget about the money, because we have to, first of all, find out whether this is a violation of official duties. And then the question about whether it was done for money is another. But what's the difference?
in the phone book example, the agent is not using something that is specifically only available to the FBI, such as the CLEAR database was here, that is only allowed to be used for official
Well,
purposes.
See, that's the question. We're going around in circles here because we don't know. And there was no evidence at trial, so far as I'm aware of, that this is only something available to the FBI, the telephone, which is all that Bailey wanted. We don't know that.
I thought you said there was a Thomson Reuters witness who said this was an FBI specific.
That's
database
correct.
That was accessed here.
That's right. There
But we
was.
don't know whether the ones that are for sale contain telephone numbers.
There was no information in the record as exactly what would be in a different database versus this one. There's no question that there was publicly available information in the FBI database. It's a matter of you get into that database by stating that you have essentially a law enforcement purpose. It's related to federal, state, local laws. And then at trial, the whole point that Mr. Aderoba, his supervisor, was making was that you are not allowed to use this database for anything but official
Right.
FBI business. So it doesn't matter whether or not the item that you look up in that system for a friend who's just paid you money or is offering to pay you money and you've agreed to take it. It doesn't matter what the exact thing is that he's looking up in that system. The point is he's used that system, which he's only supposed to use for official FBI business, in order to take money from a friend and give this friend aid, which would not be the same as just picking up a phone book in your office 50 years ago and quick looking something up. I think it's important too that the case law indicates that your job description is not just limited by what do you do when you go in the office every day. You know, Mr. Paitsel was working in an IT capacity there, working as a liaison with agents and other FBI staff to work on their computer systems, essentially, get them what they needed. The law that we've cited in our brief, including like Moorlane case and the Gajili case, they indicate that the term official duty is not cabined by a job description. If somebody asks you, what do you do on a daily basis when you go in your office? That's not cabined by I write briefs, for instance, in my case, or I do research on laws. It's also cabined by how are you supposed to act as an FBI agent? And here, Mr. Adaroba testified specifically that you were not allowed to use clear except for an official FBI purpose, and cited several regulations that talked about the specific duties that were related to this case. So this is not a matter of just having a free-for-all and just saying any ethical rule that could apply to an FBI agent. It creates an official duty. In the Moorland case, the court indicated that as long as you were cabining regulations to a specific, yes.
One of the arguments that we have to decide is whether there was sufficient evidence to convict on the bribery count, right?
Right.
And so we have to determine whether the evidence meets all of the elements of the offense. And regardless of whether the jury was properly instructed, or regardless of whether there was plain error in the jury instruction count, we have to basically map the evidence in the light most favorable to the government against how a properly instructed jury would consider it and determine whether a reasonable jury could find that sufficient, right? That's what we should do.
That's right, Your Honor, yes.
So it seems like we are going to have to decide what official duty means in order to perform that exercise, right?
Correct.
And so what does official duty mean?
Official duty here was explained by Mr. Adaroba's testimony, saying that you can't use your public office for private gain, citing a regulation for that you can't use non-public information to further your own private interest or that of another, that you also can't, in regard to the personal use of government property, you cannot use government property for other than an authorized purpose. There was also testimony from Mr. Adaroba that Agent Paitsel was trained on these regulations and that they were available to him in the FBI policy guide, so he had warning of what his duties were.
So that covers the evidence that was presented. How does that evidence meet the standard of what official duty means? What is the legal standard for what is an official duty?
I think the legal standard for what is an official duty is kind of akin to both what Moorlang was saying, what Gajili was saying, and also Fernandez. Fernandez mentioned that it was related to your job responsibilities, and that could also include regulations, rules, and so forth, which would indicate that it's not just cabin to what do I do when I go in the office every day? What is my
What job
function?
responsibility did he not perform?
The job responsibility in particular that he didn't form here is he used official FBI, or he used clear for other than official FBI work, which was unauthorized.
That then suddenly makes everything, that means taking the pen home at night, also a violation of an official duty.
No, I don't believe so here, though. There is
Government property for personal purpose.
There in other situations, such as taking a pen home or maybe making photocopies for your Girl Scout troop, though there is a de minimis use exception for things like that. But in this case, as Mr. Adaroba testified and Agent Waltz testified, there is no de minimis use for clear. You're either doing it for an FBI purpose or you're out of bounds.
What is the official act that was influenced? Which is, that's an element of bribery, right?
Only for official act bribery, and since this was official duty bribery, it was
see.
different. So we were just looking at what are his official duties.
And
How do you distinguish, you say de minimis use, but say he takes a pen home every night?
Well, I mean, at some
Here.
point, you've got a heck of a lot of pens and it's far more than just,
But
Yeah.
is that, and that might, maybe consequences for that and disciplinary reasons for that, but is that a violation of an official duty? Or is that just a human resources issue?
I mean, it would be a violation of an ethical rule if you're getting beyond
Right. And are
the
you
de
saying
minimis
any
point.
violation of any ethical rule is a violation of an official duty?
Only, and what I was trying to say, not just any violation, I'm talking about violations that are specific to what is the crux of the bribery in this case. So here, I know it's a little bit
Oh, we haven't.
big. It is difficult because it is
So
factual.
let's suppose Bailey had said, I'm starting a business and I need a lot of office supplies for my business. And, I'm, short on cash now. But I'll give you $100 and, bring me, case of copy paper and pens and notebooks and lots of office supply. And, I'd really appreciate it. And that's what Paitsel did. Did he commit bribery? Did he violate an official duty if he did that?
It's a possibility that he did.
Why do you say?
Because, well, I mean, just because he has agreed to accept a thing of value, which is the money, in return for violating his official duty, and this wouldn't be a de minimis use situation. You're essentially selling government furniture and so forth to somebody. So you have an official duty not to use government resources for non-official purposes, and this, I think that would be bribery.
Are there any ethics regulations that would not fall within, a violation of which would not amount to a violation of official duty? Or are you saying every ethics regulation
No, I'm not saying every ethics regulation. I think it does have to
would
be,
not be?
I think it has to be cabined to what is really happening in this case.
That doesn't help me with a statutory definition. So give me an example.
And that's the problem because there is no statutory definition.
No, I understand. Well, you're asking
official
this court
duty.
to adopt one.
It just,
You're asking, your friend on the other side has a concept of what official duty means that does not include this case. And your concept seems to be this case. And we can't write an opinion like that. So we need, and you say not every ethical violation is in, some are out. So how do I know which ones?
the ethical rules that apply to the specifics of the case are what defines the
That's not
official
advance
duty.
notice to the public of to what is criminality. That can't possibly be the test.
But you do have
You have to be able
advanced,
to look at the statute and know what's criminal and what's not. So we can't say what's relevant to the particular case. There has to be, I mean, if your position is every ethical duty, compliance with every ethical duty is part of your official duty, that's your position. But if you're telling me it's not, then I just need to know what's out and why.
it just has to relate to your job. And my point is
Well,
just
what
that it's
ethical
not,
duties don't
don't.
relate to your job?
I mean, I can't think of an example right off the top of my head, but the ones that are much more clearly related to what is.
Is there an ethical duty against using official work time for personal business?
There is an ethical regulation. You're supposed to put in an honest day's work and so forth. I don't think it would
So-
get
so-
that vague.
March is coming. And Mr. Paitsel, I hope I'm saying this, Paitsel, right, Paitsel, I'm sorry, Paitsel, I don't know why I have trouble with that. Paitsel is the March Madness guru for the FBI. That's a big organization. Right? That's a lot of brackets
Right.
to keep track of. And so during the relevant time in March, he's spending 3 hours a day, 2 to 3 hours a day on his FBI computer, processing everyone brackets, sending out brackets, setting up the terms of the pool, getting people to agree to whatever the prize is, and then processing as the games are played, watching the games during the day. Is that would seem to violate the ethics rule?
Right.
Would that violation be a violation? We're not at bribery yet, but would that violation be the violation of an official duty?
I don't think so. I think that one is too vague because that could apply to anybody working for the
What's too vague
federal
about
government.
it? Lots of hours, lots of computer usage,
But
lots of time.
it's
He's
not-
doing FBI work.
It's not specific to his job at all as an FBI agent. It doesn't relate to, for instance, here, like a specific computer database that he was allowed access to solely because he was an FBI agent. It's
So
just,
instead
if
of
you
going
come into the
that
government.
database, Mr. Bailey had paid him, because Mr. Bailey's computer is broken. So if Mr. Bailey had paid him to go on his FBI computer and Google around to find these phone numbers, would that have been bribery?
I don't think that we would have pursued the case
That's
as
not my
as
question.
bribery.
Would that
No,
have
no,
been-
I don't
would that have
think,
been, I didn't ask the question right. That's my problem.
I don't
Would that have
think,
violated an official duty?
I don't think that that would fall into official duty in the manners in which other cases have indicated, such as,
That's just a factual description of other cases. I'm asking you
Right.
whether that would violate his official duty.
I don't think that would.
And so the only reason this ethical violation is a violation of official duty is that it's an FBI specific database, and he has to say, I'm doing authorized FBI investigative work when he goes in and checks which box. That's what makes it part of his official duty?
That makes it part of his official duty, yes, because it is related. He has access to that database solely because he's a special agent, and that database is supposed to be used only for FBI.
Okay, so now he's
related.
going into Westlaw
Hmm.
and using his FBI username and password to find some information. Would that be for somebody, for pay?
Mhm.
Would that be a violation of official duty? Because now he's using an FBI authorized database that I'm sure they're told is supposed to be used for FBI purposes. And sometimes you even have to put like a code in for what you're working on.
Correct, yes.
So
That, I
that'd be-
think that would be official duty. That's part, if that is one of the things that he's given access to as an FBI agent, because he's an FBI agent. And when you
He's
do
given
go
access
into,
to an FBI computer because he's an FBI agent. So even for Google, he's given access to that.
right, but Google isn't really, Google is for everything. It's not necessarily
Sure,
related
not-
to your job.
But your use of your computer, presumably you're taught that your use of your computer is for FBI work. So it's
Right,
not that you're
but that's,
told-
that's very, very broad. So
Mhm.
we're not just saying anybody who spent an hour on the computer and his friend said, if you look up this information, I'll give you $50. If you look it up in Google, it's different. When you start getting into Westlaw, where you have to check in that you are working on a particular case, or, I believe that there's a warning on our system when we get in, just saying that you're accepting the fact that you're using this for your job purposes, not just going off and trying to find out information for non-work purposes. In those situations, you are then
What if he had
in
He
violation
had
of
the email addresses for these tenants, but Mr. Bailey wanted phone numbers and addresses. And so he sends an FBI email and it has FBI in his email address and the signature block says FBI agent or whatever it says.
Mhm.
And he emails them to get their, hi, I'm so-and-so with the FBI. Can you please provide me with your phone number?
Yes, I think that would be a violation of an official duty, because you're not supposed to use your,
That seems more de minimis than the March Madness.
But there's no de minimis exception for something like that, because you're just not allowed to go out and represent yourself as an FBI agent for purposes other than actually doing the work of the FBI. If this is solely because Mr. Bailey has said, I'll give you money if you get me this information, that is in no way an FBI purpose. You're essentially using the name of the FBI to get personal information for your friend. And that would definitely be a violation of the official duty. And I believe that was one of the, that probably falls under 2635.702, use of public office for private gain, either your own or that of a private gain of a friend, which was one of the regulations that Mr. Aderoba testified about at trial. So for all of these reasons, we believe there's sufficient evidence of an
Can I
official
tell you would
duty.
define official duty then, using your FBI position and resources?
For non-government use, for private.
Because it doesn't cover March Madness or Googling on my FBI computer.
No, because you're using FBI resources that are only available to the FBI. I mean, frankly, anybody could get on Google and look
So
up.
the use of
same
FBI
thing.
resources to obtain information exclusive to the FBI for a private purpose.
Right, and in the case of
So
Westlaw,
we
it's
said the
not
phone number-
necessarily exclusive. In the case of Westlaw, that wouldn't even necessarily be exclusive to the FBI, but it's
Well,
definitely,
if it's not exclusive to the FBI, then, so that's not part of your test?
I'm sorry, Your Honor, I didn't catch
So
that.
it's not something that you can only do because of your position?
Well, I mean, the only reason if you were working for the FBI that you would have access to it is because of your position. So yes, that would be violating official duty.
The only reason I have access to the FBI computer, I get I could do Google on something else, but say my
Right.
computer at home is broken. So the only reason I have access to Google is because I'm using my FBI computer. But you still say.
No, you could still, I mean, frankly, look that information up on your personal phone while you were sitting in your office. At the
All he
FBI.
has is it's the only way he's got to get Google.
I don't think that would be violating an official
So
duty.
what's the difference between that and Westlaw?
Westlaw, you have really no access to that except for the fact that you know, in the same with Clear in this case, he has a username and a password and an
private people
account
can
set up
access
by the FBI.
Westlaw?
I'm sorry, Your Honor.
People can access Westlaw without being part of the FBI.
Yes, but no matter where you're working, though, you are given by your employer an access username. An account is set up for you by virtue of the fact that you are working.
Account set up for me to sign into my computer every day. I'm trying to figure out what the line here is.
Well, the line
If
is
I'm
that
using the computer for March Madness, you say that's hunky dory.
it's a,
But if I'm using it to help Mr. Bailey get some phone numbers, that's not.
right, because and I'm assuming this about the court is that by virtue of you being a judge, the court has set up and contracted with the company to give you an account for Westlaw because of your job.
Mhm.
Which is just different than going on to Google because it's available just in general. You don't have to have an
You're still
account.
using a government resource to do that.
It is a government resource, but
That's not if your position is that if everyone else can get the information anyhow, that seems to hurt you in this case because presumably the other people could get phone numbers.
well, this was the exact problem in this case. Though,
Phone
is Mr. Rice, who had been a skip tracer for Mr. Bailey, was having no luck getting the information that he really needed. And particularly, he was having no luck getting it in a timely manner, which is really what this all came down to. If you wanted to get TOPA rights from these tenants, you had to be quick about it because there were people trying to pay or get tenants to assign rights to their buildings very, very quickly in order to hop into the transactions and make money off the real estate transactions. So as was testified to at trial, I believe by Agent Waltz, is like using Clear it was an aggregator of a lot of information. It gave more accurate information than Google or whitepages.com or Spokio or any of these things. And it gave it to you very, very quickly. Which you can really see when you look at the evidence of the searches that Mr. Paitsel did. He was able to get back to Mr. Bailey very quickly and provide additional information.
So let's suppose Bailey said, I need to know all about TOPA. I want to try to, do this scheme where I buy people's TOPA rights. So I'm going to give you $500, and can you access Westlaw and print out like TOPA law, any regulations, and all of the cases that the DC Court of Appeals has decided relating to TOPA? And that's what Paitsel did. He accessed Westlaw, not Clear.
Mhm.
And he downloaded all that information and sent it to Bailey, and for the $500. Did he violate an official duty by doing so?
If Mr. Paitsel had the same sort of warning that we have on our computer saying that you're doing this essentially for FBI business only and, perhaps even having to state a case, then yes.
The hypo, it doesn't. He just has to sign in using his username and password for Westlaw, but there is no such warning other than that.
I would still say the same because and again, this wasn't something that was testified to at trial, but it would be highly likely that Mr. Adarabba would testify that you can't use Westlaw that's given to you as an agent to then go do lookups for your friends or
So
non-work reasons.
So the definition of official duty hinges on whether there is a policy, practice, regulation, rule of the FBI that states you cannot use this sort of information that is an FBI resource for your own personal gain.
Correct.
That's what it turns.
Correct, yes. In fact, in the FBI policy guide, there were examples given of what sort of things would be wrong. Like, for instance, there was one saying that you can't look up criminal history of a public figure. You can't check into the background of a person who might be dating your son or daughter, those sort of things. Those were all given as examples of improper use of FBI resources.
Checking out whoever dates my daughter is a very authorized resource. Really? You won't let me do that?
I'm afraid not, no. If your honor had any questions on the jury instruction issue, I'm happy to answer them. I would just say that there, as has been pointed out by the defense, Mr. Paitsel proposed the instruction of official duty as it was given, and in the end, he endorsed it. And ultimately, the official duty instruction that was given in count 5 was the exact instruction that he had originally proposed. And even though later on he had asked for a change after the end of the defense case changed, he asked, after all the discussions were over, can I change the word corruptly to with corrupt intent in that instruction? The court said no. And even still at that time, he didn't say, I want any change to the language of the instruction about defining official duty.
I don't think my colleagues have any more questions. Do you have any other important point?
I don't believe so, Your Honor. I respectfully request that the court affirm the judgment of the district court.
Thank you.
Thank you.
Ms. McNamara, we'll give you 2 minutes.
Thank you. I just really want to make one point. And I think one thing that we all know from today's discussion is that what official duty means is very hard to determine. And I think that in this case, the rule of lenity therefore compels this court to construe that statute in a way that does not create an incredibly broad, all-encompassing interpretation that includes violations of any type of ethical obligation. We've cited cases on page 12 of our reply brief cautioning against doing that, and I would caution the court against doing that here. Are there any other questions?
All right, thank you very much.
Thank you
Case
very
is
much.
submitted.
Thank you.
Case number 24-7022. Nicole Pileggi, individually and on behalf of other similarly situated appellants versus Washington Newspaper Publishing Company, LLC. Mr. Hammack for the appellant, Ms. Konopczynski for the appellate.
Morning.
Good morning, Your Honors, and may it please the court. I'm Joshua Hammack on behalf of Nicole Pileggi. I'd like to reserve 2 minutes for rebuttal. This appeal concerns what it means to be a consumer under the Video Privacy Protection Act. The statute defines consumer as, quote, any renter, purchaser, or subscriber of goods or services from a videotape service provider, unquote. But the district court required those goods or services to be audiovisual in nature. Effectively, it inserted the term video or audiovisual into that statutory text. As this court is no doubt aware, the Second Circuit recently resolved this exact issue, and it disagreed with the district court's approach. Addressing the meaning of goods or services, it concluded, quote, the VPPA's text, structure, and purpose compel the conclusion that the phrase is not limited to audiovisual goods or services, unquote. And the case overruled the very precedents from the Southern District of New York that the district court here relied on to reach its decision. The Second Circuit got it right. What we're really talking about here is the VPPA's one-sentence liability clause. We're not talking about what it means to be a consumer in the abstract. We're talking about consumer as that term is used in the VPPA's liability provision, a single sentence alongside 2 other separately defined terms, videotape service provider and personally identifiable information. And it's important to keep in mind that the Act requires all 3 elements together, VTSP, consumer, and PII. Let's start with videotape service provider, which the statute defines as any person, quote, engaged in the business of rental, sale, or delivery of pre-recorded video cassette tapes or similar audiovisual materials, unquote. Think Blockbuster, the quintessential example of a videotape service provider, a brick and mortar store engaged in the business of renting out VHS copies of movies.
I'd rather think about newspapers because that's what this case is about, if that's okay. And my question is, how does the statute work under your definition? So if I pay the Washington Examiner to post a wedding announcement, and I obviously have to give them contact information, things like that. I pay for the wedding announcement. Now, every time I go on their website, they have to make sure the megapixels don't follow me?
Well, not necessarily. What they have to make sure they're doing is not disclosing your personally identifiable information, which is not just.
I am now a purchaser. I fall within the meaning
Correct.
of.
Oh, I agree. You're a consumer in
I'm
that
a
scenario.
consumer.
Yes, I agree.
And if I'm a consumer and I go on their website, they can't fax me. I mean, that's your whole case, is that as a consumer here went on the website and they were tracking her information.
I don't think
Video
that's.
information, video watching information.
I don't think that's the whole case, because the important thing, first of all, personally identifiable information, recall, has to connect the user to specific video materials or
Right, I
services.
go on the website and I watch videos.
And then the VTSP has to disclose that information without
Well,
informed consent.
again, it's the same, I don't understand how this is different from your case. Except she bought a newsletter, I'm buying an advert, a notice about a wedding.
Right?
So we're the same position.
I agree that you both are consumers in that
Right.
scenario.
We're
Yes.
both consumers, and the issue here was that Miss, and is it Pileggi or Pileggi?
Pileggi, I believe.
Pileggi. Pileggi goes on the website and watches videos. And when she's there, they nab her video watching information, maybe some other PII, and send it off to Meta.
Right. The
Okay, and
disclosure is
my
the
hypothetic-
violation.
Sorry?
The disclosure is the violation. Right.
I understand that. And so I've bought the wedding announcement.
Right.
And then the next afternoon, I go on the website to watch some videos. And they snatch my information, or automatically collect it, I guess is the right thing, and send it off to Meta. That would be a violation in your view.
Yes.
Okay.
And
How
that
are,
would subject the Washington Examiner to a minimum of $2,500 a person,
Correct.
and they have 100,000 subscribers.
Give or take, sure. Yeah.
Yeah. So what's that, $25 million?
Ooh,
Or
I was told there would be no
200
math, Your Honor.
I don't know. You're very confident that, that your client is a consumer, but one of the things you leave out in that equation, it seems to me, or at least don't stress, is whether the Washington Examiner is a videotape service provider.
And there's a reason for that. The district court below assumed that the Washington Examiner was a VTSP without resolving that question,
Right.
basically
I
deemed it wasn't
understand- I
material.
understand that.
Mhm.
But your argument with respect to that question says, well, it stresses the video part of that videotape service provider, right? And so if the Washington Examiner or anything is putting out videos on their website, then they qualify as a videotape service provider.
Well, I think they have to be in the business of providing those
Right.
videos, but yes.
What happened to the word tape? It seems to me that that's just as important, as maybe even more important functionally than the video part of it. It's an object. It's a physical object. If it's a tape, I can see the argument that a DVD is the equivalent. But I don't see any physical item here that's being provided. And let me just round this off with two other thoughts, and you can respond, okay? It does also seem to me that what we have here is a statute that technological developments has rendered obsolete, and Congress really hasn't attended to it. And you know, there's arguments by constitutional lawyers about the living Constitution. I don't see why the statute ought to be a living statute when, for the judiciary to try to adjust it to technology that has rendered it obsolete.
Well, so 2 points, Your Honor. I think the definition of VTSP is really the only place where you find the kind of physicality requirement. But it also includes kind of a catch-all at the end of that definition.
I know the catch.
Or similar video, audiovisual
That doesn't
material.
answer the question. Similar to what? Similar to tapes? It's a physical, tapes are physical objects. So if to be similar to a tape, it has to be a physical object.
Well, I don't think any court has held that it has to be similar in terms of physicality. I think it has to be similar in terms of
What I care
delivering
about is
video.
What I care about is the precedent in this court. And we have no precedent dealing with that question.
I think that's probably right, but it's also a question, Your Honor, that the district court didn't resolve. So I think if you want to reach out and resolve VTSP status, that's really something for the district court to decide in the first instance, not this court to resolve.
Yeah, but I'm not willing to accept, without knowing that, I'm not willing to accept your, advocacy that it's clear that your client was a consumer. I don't know that unless I know what the definition of videotape service provider is.
Well, again, that's exactly what the district court assumed here, right? Assuming that they are a VTSP, do we meet consumer status? And the district court said no. That determination was wrong. The answer should have been yes. That's exactly what Salazar holds. So the answer should be yes. Now, remand back to the district court.
Salazar didn't deal with the question I'm talking about, the tape.
It actually did. At least maybe not directly, but it has language that sheds light on that exact question.
It didn't analyze it.
Well, no, that's not true. It did in fact analyze it because it said entities that as some part of their business deliver video content, even if it's a relatively small part of their business. It's not just Blockbuster, it's other companies
They
too.
didn't analyze the meaning of tape.
Oh, I guess that's true, Your Honor. They didn't focus in on the meaning of
Exactly.
tape particularly. That much is true.
I wanted to get back, are you done with that one? I wanted to get back to my hypothetical. How is this supposed to work? How is the Washington Examiner supposed to know which people who previously took out an ad, 'ad, 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 ' bought a keychain from their gift store are the ones that are now on the web.
Well, I mean,
How are they supposed to, I don't understand how they're supposed, I don't understand how this works.
there are a couple of ways for them to deal with that problem. One is to track consumers. They have a list of information about their consumers and they know if they're sharing that information with other people. That would be one way to do it. Another way to do
Doesn't
it.
automatically take the information. They gather, this metapixel process gathers the information, Washington Examiner looks at it and says, okay, we'll release this one, but not that one.
Oh, I understand. You're saying on these specific facts, they couldn't do that because Pixel is operating behind the scenes automatically. That much is true.
That was my hypothetical, which I think is identical
Right.
to your case.
No, absolutely.
I bought a wedding announcement instead of subscription.
Absolutely. I agree now. But my point was,
I mean, the reading, sorry, just to spell out the thought here, I apologize. The reading that there's no nexus requirement between the purchase of a good and the watching of videos becomes unadministrable. Either it just requires any video service provider who's sold anything to anybody to not gather the information full stop because they've got no capacity to determine which of the people on its website within the last year bought a product from them.
I don't think it's inadministrable, Your Honor. And I think it's true that they couldn't do it automatically the way the Pixel does now. They would have to have some administrative step to determine whether that individual is a consumer. But another way out would
Does
be
the technology allow that?
I don't know the answer of whether the existing technology allows that. It might require some innovation, or it might just not permit this particular use of the technology that violates consumers' privacy rights. But there's also, of course,
Well,
informed
it's not
consent.
consumers. I mean, if there's no way to differentiate who's on my website, whether they're a consumer, whether they're a purchaser, renter, subscriber, bought anything from us, then they just can't, they have to just not collect it at all for their own purposes, let alone for Meta.
I don't think that's right. I don't think there's any reason they couldn't collect it for their own purposes because, again, disclosure is the thing prohibited. You have to have a disclosure of PII.
It have to be disclosure to a third person, or can it be a disclosure to, another part of the Washington Examiner company?
I'm not sure that I've ever seen a case that involves
just
that
asking what the
question either,
statute means.
but no, I don't. I think it has to be to a person who is not the person who is the VTSP. In other words, a
Well, I don't know what that
non-VTSP.
means when you've got something like a newspaper that has lots of written news content and has some video content, probably has different people managing the video content than writing the news stories. There's an editorial board over here. If they disclose the information within the entire entity, is that a disclosure?
I don't think so. No, Your Honor.
So it has to be someone outside the company, not outside the video service provision portions of the company.
Correct. I think that's right.
And
Because
that's
a
textual.
VTSP is a VTSP as a unit. Washington Examiner as a whole is a VTSP,
Mhm.
not just this one branch of Washington Examiner is a VTSP. So in other words, look entity-wide,
Mhm.
and the disclosure has to be outside of that entity to a third party who is a person under the statute.
Okay, and it says that, that's how you're reading the word disclosure.
Correct.
Okay.
Yes.
Okay.
Yeah, and I think if,
So if you're right, if no nexus is required, what the statute does is simply forbid all sales by any entity that shows maybe a single video on its website to third parties.
I don't think it does that, Your Honor. And there are a couple of reasons,
It
but
just would, because there's no way to know when someone then comes to watch the video if they were the person who bought the newsletter or the ad, or your candy bar, or whatever it is you want to talk about. They have no way of knowing that, and there's no way of differentiating that. And so it's essentially, it's strict liability statute. Anybody, if we do it for anybody, we have a risk of sweeping in one person who bought something from
I
it.
don't think that's right. And again, there are a couple of touch points. In this iteration of the example, you said that there's just one video on the website. Well, I'm not sure that just one video in collection, in comparison to all the other things that you do on the website, news and other stuff, would make you be in the business of delivering video content the way that would be required for a VTSP. So it's starting to sound like maybe the example here has slipped away from.
So what percentage of what the Washington Examiner does is word news versus video?
I don't know the percentage.
Well, it seems like you have to know that. You just said it depends on how much you do.
No, I'm saying it depends on whether you're in the business
I know, but
of
you said the business would
delivering.
depend on volume. You didn't like the one video situation.
I don't think that one video necessarily would be enough to
Right,
make you
so
be
what would
in
be
the
enough? What
business
is
of
enough?
delivering videos. I don't have a threshold in mind, but
But if that's your test, I don't have any sense of, I confess to not having been on the Washington Examiner website. And so I don't have any sense of what the percentiles are. If it were 5% video, is that in the business?
I don't know. I don't know how you would even measure it in a context
Right,
like
well, then it
this, where
seems like-
every article has a video accompanying it.
Every article has a video.
I
accompanying it?
believe that's the allegation, that these videos basically appear at the top of every article and they autoplay. You have to turn it off to stop it from
Are
playing
these
when you open
videos
the
about the
website.
news or are these advertisement videos?
They can be both. They can start with an advertisement and run into something that's related to the article.
Okay, so now these website companies can't have ads on their websites either because there's a risk that some consumer might come onto their website.
Why couldn't they have advertisements? I don't.
If they're playing, all the ads I see on websites are automatically playing, as you say.
Right.
And if someone who's a consumer goes on, they can't, I mean, unless they're not collecting any information. I assume the reason people want to be on there is they're getting, the reason someone wants to advertise on your website is they've gotten this information about somebody and knows that these people on this website might be interested in this product.
Well, I think
Do
that's
it.
exactly right.
So they will, there's no, I don't know how the advertising system works if they can't provide information about who comes to their website to the people they're asking to advertise on the website.
It would work precisely by obtaining informed consent from the consumers whose information you're sharing. That's the only step.
But again, unless you have a firewall that says the only people who can come on to our website fill out this statutory informed consent form, you're not going to have a normal website that anybody comes to, right? No one will be able to access it because you can't know if that person, there's always a risk that any one of those people will have purchased, rented, or subscribed to something from you.
Well, hold on. I guess I'm not sure I'm following now because I think that the differentiator would be whether that individual, consumer or not, provided informed consent, basically checked, yes, I'm okay with you sharing my data.
Is that all they have to do? I thought your argument, because they argue that that's what Ms. Pileggi did here, and you said, no, there's this, I mean, I know the district court didn't decide this yet, but no, there's a statutorily required consent form.
That's true in this case. There
Does
is
it
a,
have to be the statutorily required consent form, or is it just a check yes consent form?
well, no, it has to be the statutory
Okay, well, that's more
required.
than check yes, isn't it?
No, it just has to be separately set out that we are going to share your information, your video PII with third parties. Check yes. And if the consumer
have to
or
opt
the
in.
non-consumer checks yes, then share the information. And if not, don't share the information. That's simple enough.
But they're gonna have to have, that's gonna have to be sort of the wall before anyone gets to their website. Everyone will have to check that box coming in every time they come in.
Right, just like any other terms of use box appears on lots of other websites, yes.
No, usually it does when you're signing up for a service. I've never checked one of those boxes going on to a website.
Well, that's a fine point. You could sign up, you could do it as an entry point into signing up for a service, a separate consent form that sets forth, we're going to share your PII as defined by the statute with third parties. Are you okay with it? Yes, no.
The argument you're making is based on the idea that a subscriber does not have to be a subscriber of audio-visual service. Is that correct?
That is absolutely correct, yes.
And-
That's the way Congress wrote the statute.
Right, but that's not the way you argued the case in the district court.
I disagree with that, and this brings up the waiver argument. But I disagree with that wholeheartedly. And if you look at our brief, which is ECF 22 below, our brief opposed to the motion to dismiss, Section C of that brief concerned Ms. Pileggi's status as a consumer. Part C1 had the heading, quote, plaintiff's newsletter subscription makes her a subscriber and thus a consumer protected by the VPPA, unquote. That's the exact argument Washington Examiner now claims that we didn't make. There's a whole section of our brief devoted to that precise point. And on page 19 in that section, near the end of that section, Ms. Pileggi specifically argues, quote, as in Yershoff, plaintiff has plausibly pled that because she gave Washington Examiner her personal information and signed up for a newsletter subscription, she is a consumer under the VPPA, unquote. So there was no waiver here. This is the exact same argument we made below. There was a second argument under Part C devoted to basically, even if those SDNY courts were right, and it needs to be some audiovisual material, it just so happens that the newsletter would meet that requirement too. But that's an argument in the alternative. It wasn't the only argument we made, and it certainly wasn't a concession that go ahead and rewrite the statute to require audiovisual materials in terms of consumer status as opposed to PII.
It seemed to me you were arguing a different point with respect to consumer. And it also seems to me that the district court was well acquainted with what you were arguing. And the district court said the plaintiff did not dispute to be a subscriber and the VPN subscribing to audiovisual services and not goods or services writ large.
Well, so the district court did say those words, and it looked at Part C2, that alternative argument, when it said we made that concession. It ignored Part C1, which is where we said she's a subscriber to a newsletter and thus a consumer under the VPPA. That's the exact same argument we made here and are making now. That's the exact same argument that the Second Circuit credited and that we think resolves this appeal.
On the issue of whether one has to be a purchaser to be a subscriber, isn't it relevant that in the heading of the statute, as it appeared in the public law publication, and it's the same heading is in, you look at the statute on Westlaw or, US Code. For section 2710, it says wrongful disclosure of videotape rental or sale records. So Supreme Court has told us, and we have cases in our court telling us that you can look at those headings to help, interpret the language in the statutory provision. So doesn't that support the argument that you've got to be a purchaser, where Congress put the heading of the whole thing? It's videotape rental or sale record, because doesn't rental or sale necessarily comport with purchasing? And so therefore, subscriber is somebody who rents or purchases by subscription as opposed to like on a one-time basis. Why isn't that the best reading of the statute?
So no, Your Honor, I don't think you can read the statute that way. And to get to the point where you're using a heading to interpret a provision and its meaning, you have to have some ambiguity, right? That's step one. Find an ambiguity that we need to read the heading to help elucidate which permissible reading is the right one. We don't have an ambiguity here. We have renter, purchaser, subscriber. Those are three different things.
Well, there's an ambiguity. I mean, this whole fight we're having here is about what the subscriber. You're saying that subscriber is an unambiguous term.
I do think so, and I think there's another.
There's some definitions that say the subscriber has to be a purchaser, and then there's some definitions that don't mention purchaser. So why doesn't that make it ambiguous?
Well, even if it were ambiguous, which again, the district court didn't hold that, Washington Examiner never argued that precise point, but even if it were ambiguous, there's another canon that does the work before you jump to, well, let's look at just the heading and go with whatever the heading says. And that canon is you can't just read a term out of a statute. You don't read it as if Congress put in a term that has no meaning. It's just surplusage. And this reading, what you've done now, or what you're suggesting here, would read subscriber right out of the statute. Every subscriber under that view would be a renter.
The subscriber is, I mean, Netflix was completely changed the game precisely because they created this whole subscription method of renting DVDs. It didn't mean that subscribing was the same as renting. It meant that it was a particular type of renting. Way back in the day, I'm old enough to be your grandpa, where I had a membership to Columbia Records. And you as a subscriber, you could get a new album or CD mailed to you, every month or periodic. Didn't mean that subscription was the exact same thing as sale. It's just a different way of selling.
Well, I think that's the problem, though. You're basically saying a subscriber is a subcategory of a renter or a purchaser. So subscriber never does any work on its own. It has no independent meaning. It's just some subset of renters or some subset of purchasers. But why then would Congress put it into the statute at all? If it has no independent meaning, it's doing no work. That's exactly what the Supreme Court has many times said not to do. Don't read terms out of the statute. Don't create surplusage where you can avoid it. And here you can avoid it by simply holding, well, of the two permissible meanings, assuming we have an ambiguity here, we have to adopt the one that gives some independent meaning to subscriber. And that means you don't have to pay money to have access to the service or the good at issue here.
Doesn't it do some work in the sense that it's a it's serialized renting or sale? You're just saying that doesn't count because that's still just a subset of the other two items in the list.
It sounds like the same exact principle, right? You're renting it for a longer period of time, or you're purchasing it in a different way. But what you're still doing at bottom is either renting or purchasing that good or service. There isn't a third category that subscribing is touching that isn't one of those other two things, at least as I understood your example.
The Washington Examiner comply with 2710E of the statute? Under your theory.
I'm not sure I followed. This is the destruction of old records one.
Yeah.
So information that they had already collected as of 1988 had to be destroyed within a year.
But how do they destroy it?
Oh goodness, I don't know how I assume there were paper records.
Is it even possible? That's my question.
I don't know the answer, but it wasn't an issue at all in this case.
Yeah.
There's something about the newsletter, and there's allegations that it has hyperlinks in it.
Correct.
And elsewhere, there's allegations that there are videos on the website that if you click on, immediately start playing.
Correct.
Do the hyperlinks in the newsletter, if you click on those, do they just immediately start playing? Or do they take you to the website and then you have to click on the little arrow or something to get it to play?
I believe it's the former. They take you to basically the website or an article on the website, which includes a video that automatically starts playing.
But there's no allegation about that actually in your complaint.
I don't think there is an allegation that she clicked a newsletter link and that's how she accessed an article or a video.
It automatically starts playing? Don't you have to click on the screen to get it to play? I mean, the triangle on the side?
No, that's not the allegation contained in the complaint. The complaint says that the videos automatically start to play when you click the link or open the webpage.
And is this advertising videos or actual material provided by Washington Examiner?
Well, again, I don't want to draw too fine a line between those things because it might be one that runs into the other. It might be an advertisement that starts playing and is 5 seconds long or whatever, and then it runs into a video that's about the content of the
Okay, and if I were to just go on the website, so not going through the newsletter, and you said there's things already automatically playing, are those only ads?
I don't believe so. I think it's the same
Okay.
situation.
Can they collect information from me if I'm just looking at the website, or do I have to click on something?
You mean like, does the pixel work?
If I just, yeah, this Metapixel thing, if I just go to the website and I'm just looking around on it, but I haven't clicked on anything, but things are running, they're not collecting any information on me.
I think they could be collecting information on you, but I'm not entirely sure
Okay.
in that scenario if they are in fact.
Okay. Thank you. You have a question?
All right, so for all of those reasons, Your Honors, and those in our brief, we ask that you reverse the decision dismissing the complaint.
We'll give you a couple minutes for rebuttal. One.
May it please the court, Grace Konofchensky on behalf of the defendant appellee, the Washington Examiner. The court should reject plaintiff's attempt to turn the narrow 1988 Video Privacy Protection Act into a broad internet privacy statute that would upend the modern internet. The act is fundamentally about protecting the privacy of purchasers, renters, and subscribers who request or obtain videos, not goods or services writ large. And as your questions indicated, Judge Millett, plaintiffs' reading to extend to goods and services writ large, particularly without any knowledge, would make compliance with the statute almost impossible. I'd like to just give some of the facts from the amended complaint. The complaint alleges that the Washington Examiner.
Why is compliance, I mean, you've got knowledge, you had an arrangement with someone, they bought something, you got information from them, and you know that you got Metapixel going on your website, so.
But we have there are no allegations that there is knowledge when the disclosure occurs. That the Washington Examiner knew which visitors to its website were consumers within plaintiff's definition of consumer. And so it did not know that the information it was disclosing belonged to
know?
a consumer.
It did know when a consumer came on the website?
It did not know. I'm sorry if I
It
misspoke.
has the information.
No, Your Honor, it has, when Ms. Pileggi visited the website, she was the same as any other individual who navigated to that
What if she clicked
website.
on a link? I know there's not an allegation in the complaint, but if she clicked on a link in the newsletter,
If she had clicked on a link in the newsletter, that might address our knowing requirement, because
that would be knowing, but it also would be a nexus, the very product that she bought for this purpose of having information and things to look at. She clicked on the link, and that's what collected her information because it automatically started playing, or even without playing, maybe it collects her information. That would be a pretty tight nexus.
I don't believe it satisfies the nexus if anyone else could navigate to that website without the
They
link.
couldn't do
I would
it-
agree.
They couldn't do it. They'd have to go on the website, find the link, and directly click on it. Whereas here, part of the newsletter is we serve it to you on a silver platter. That's what you're giving her.
Yes, but when you visit the website, she would be no differently
No,
situated
but you're
than
packaging
any
it up for
other.
her, making it very easy for her to get it organized and under topics. So that is, they're the good she has bought is, amongst other things, access to this video and ease of access to this video information.
I think there is a difference there, Your Honor, but that's also not what she alleged. She alleged that the newsletter access was separate from.
She could on remand allege, if an amended complaint could allege she or somebody else.
No, I don't believe so, Your Honor, because this is actually already her amended complaint in response to our first motion
All right,
to
it's a different
dismiss.
case. If someone alleged, I'm trying to understand the nexus theories here. If I subscribe to the newsletter, which I assume you tout as specialized information, that's easy, nice packaging for you, and I click on the link that's been nicely packaged for me, nicely categorized. I don't know if you tailor these to their interests, but whatever. And I click on it and immediately my information is collected. Because it, not me, takes me to the website. But all I know is a video is playing. There's a pretty tight nexus there.
I think that there is a tighter nexus than in the allegations in the
think there's
complaint.
about
I
as
don't
much
think
nexus as you
there.
could have.
No, Your Honor, I think it's different if there was a paywall that existed such that the only way to access those videos was by clicking through the link in the email, then I would agree with you, Your Honor, that assuming that she paid for the access to the newsletters, to go to Judge Wilkins' questions, that would make her a subscriber to the videos that are only available on the website to people.
If I subscribe to a newsletter that is described as providing me videos and presumably written information, I have not subscribed to the video information in that newsletter?
You have not subscribed to the video information that is then allegedly disclosed in by the Washington Examiner, which is the video information on the
You don't
website.
subscribe to the disclosure of your PII. You subscribe to the video service.
Yeah, it's subscribing to the videos that the Washington Examiner has then allegedly disclosed. But again, there were no allegations about that here, even in response to our making this argument in our first motion to dismiss. This is already an amended complaint that was responding to those arguments here. And then to go to Judge Wilkins' questions about subscriber requires a payment. We pointed to multiple dictionary definitions from the time of enactment, which are the only dictionary definitions that are relevant to statutory interpretation here, all of which require a payment in order to be a subscriber. And so the courts
I
that,
thought I saw some that did not. I mean, I thought that there was it's a Webster's that, Third New International Dictionary. It says, subscribe is to enter one's name or publication as a book or newspaper or service. And there was no reference to payment.
so I believe that Ellis cited a dictionary from 1981 that would probably be a contemporaneous dictionary, but the definitions that were provided in that dictionary either didn't have to do with goods and services. We don't dispute that John Hancock subscribed to the Declaration of Independence, or that you can subscribe to a political party or a set of religious beliefs, but those definitions don't correspond to goods and services. The only definition there that kind of applied to goods and services was a subscriber of telephone equipment. And someone who subscribes to telephone equipment in the 1980s was clearly paying for the telephone company to put the equipment in their house or place of business. And it's not just the dictionary definitions, Your Honor, it's also the use of all four terms in conjunction with one another.
If there's a dictionary definition that said, define subscribe as to receive a periodical or service regularly on order.
I think the on order connotes a payment there, Your Honor.
Really?
I think that's the most natural reading of the term, especially when you're
Really?
looking at three.
People sign up for little local newspapers you don't pay for, newsletters. We got newsletters.
I mean, I think in the modern reading, yes, we sign up to, and we are subscribers to newsletters all the time, but that's.
They may not be as pervasive as they are now. But there were things you could sign up to, and they would send you sort of a monthly mailing or twice a year or whatever it was. And
I think the preponderance of the dictionary definitions all require the payment term. And particularly when you combine subscriber with renter and purchaser as the definition of consumer, the use of those four terms together, statutory terms are known by the company in which they appear, all require a payment. And Congress, I'm sorry.
Not when one would serve no purpose.
No, Your Honor. I think that their subscriber is not rendered superfluous in that
How is it
situation.
not? If I have to pay for my subscription, am I purchasing something from the person who sends out the subscription?
A purchaser of video goods pays for permanent control of those video goods. A renter pays by the good for temporary control, and a subscriber pays a set amount, typically in advance, whether or not they take any videos at all. It's a set monthly, typically recurring fee. So those are three different relationships.
I don't understand that at all. When you sign up for the newsletter, if there's would you like our newsletter? It's a $5 a month charge, but you get discounted prices on the videos. Right, so that's how it's supposed to make it worthwhile to you. Have I purchased something from the entity that is providing that newsletter?
You
Have
are,
I purchased something? Yes?
you could say that you had purchased a subscription,
Didn't
but I think then you're reading subscription back into the statutory terms.
Sorry, am I a purchaser of that subscription?
You could be a purchaser of the
Am I a purchaser of
subscription.
the subscription?
Yes, Your Honor.
Okay. Is a subscription a good or service provided by the video service provider?
A subscription could be a service provided by a video service provider, but I think
So
we're,
I will have purchased, when I sign up for this newsletter and give them my $5, so I can get discounted movie videos, I have purchased a good or service.
I think you're going then to a level of abstraction
I'm
where
not
you would.
abstract at all. You just said I've purchased it and it's a good or service. I see nothing abstract about that.
I think that could actually render rental and goods also superfluous
Yeah, so
within the
that's problem with
statute.
requiring purchases. If you don't require purchases, you don't require monetary payment. If you do pay, it could still be a subscription, but you don't require it. Then they all three have independent function.
No, Your Honor, the definitions of subscriber from the time primarily required payment, they're all used as definitions of the term consumer, which also requires payment. Congress also enacted or referenced a Cable Privacy Act.
I have to pay to be a consumer?
The definitions we point to, yes, Your Honor, they all reference payment from the time of enactment.
Is there any evidence that any place in the United States that was a videotape company or whatever, gave their tapes away?
I'm not aware of any evidence that they were giving tapes away. I am aware of evidence that we cited in our brief of subscription services that existed at the time of the enactment where you paid a set fee per month for unlimited access to
Like
those
Netflix.
videos. Excuse me, Your Honor?
Like Netflix, when they were
A precursor to Netflix, Your Honor.
doing DVDs?
Yes, so this was still using VHSs at that time.
Questions? All right.
So I see that I'm out of time. With that, we would ask the court to affirm the district court's decision below.
Thank you.
Thank you, Your Honor.
Okay, Mr. Hammack, as I said, we'll give you 2 minutes.
Thank you, Your Honors. Just really quickly, I want to talk about that nexus point one last time and point out the fact that Congress wrote these two separate definitions in A1 and A3 very differently. A1's definition of consumer requires a narrow relationship, rent, purchase, or subscribe, to broad content, goods or services. A3 does the exact opposite. It looks for a broad relationship, request or obtain, even a freestanding request counts here, to a very narrow set of content, specific video materials or services. So there's just no
I'm
way.
not sure that works because it's not goods or services, period.
From a
And it's
videotape
not
service
goods or
provider.
services of a video service provider. It is goods or services from a video service provider. And isn't the assumption that the good or service that come from a video service provider are going to be video services?
Absolutely not. And in fact, look at A3 and it has that same formulation of from a videotape service provider.
Mhm.
What that tells you is that it is possible for a videotape service provider to have both specific video materials and services and separately goods or services. One might be a subset of the other. A3 is going to have a subset of what is in A1, but they're
Maybe
not
A3 is
entirely the
confirming-
same.
It's confirming what the from meant.
I disagree, Your Honor. And again, that would mean that Congress used these different terms, different relationships to different content to mean the exact same thing. And that violates like the primary, the cardinal statutory interpretation
Not if you
mechanism.
read from a video service provider as requiring a nexus.
Well, if
You
from
have
is
that
the,
nexus in both provisions, which would be parallelism.
then why would it have goods or services in A1 and specific video materials or services in A3. There'd be no reason if the nexus exists in from.
That's the type of personally identifiable information that they're including. Remember, it's an includes language there, and so they're specifying one particular thing.
But we have to look at what is the content that we're talking about here. Are we talking about any good or service, or are we talking about a video? And if from is the thing that makes it a video, from exists in both places, why would we need the video modifier in A3
And
but not
suddenly the
A1?
statute is, under your interpretation, is requiring all now audiovisual service providers to stop collecting PII on who's looking at what or requesting what. They'd have to, because there's no way otherwise to protect yourself against someone who happened to also have bought something from you coming on.
Again, I disagree. You don't have to stop collecting it. You have to stop disclosing it without consent. That's the piece
I know,
that you
but
have
that's
to
the
stop
reason they
doing.
collect.
Well, of course, that's the
I don't know
reason
if
they
Washington
collect.
Examiner even has the technology to collect it. They've got Facebook collecting it.
Fine, I can accept that point, but the problem
Do you
isn't
know
the
how many-
collection.
How
It's the,
many websites in this country that would qualify under your view as a video service provider?
I don't
Whether
know.
it's newspaper, there's got to be hundreds of thousands, probably millions.
There are
Million.
certainly a lot
Is
of.
it common
video-
or uncommon to collect information from users who come to the websites? Do you have any idea?
I do not know. I don't know. I mean, certainly you've got something as ubiquitous as Facebook involved, so it's probably, somewhat common, but I don't have a percentage that I can quote to you today, Your Honor. But the point is,
A lot of work for a 1980s statute about videotapes to do.
it might be that things have to change from their current form, but that isn't a reason to read out of the statute the words that actually exist there. That's not a good reason to read out the actual terms Congress enacted. We have to follow those words. That's the cardinal principle for statutory interpretation. So again, we ask that you reverse the decision below. Thank you.
Thank you
Your
very
Honors.
much to both counsel. The case is submitted.
This honorable court stands adjourned until Tuesday, March 1st at 9:30 a.m.